On the legality, whether the court has jurisdiction to test the legality of policy positions, we have made extensive submissions, Honorable Chief Justice. But I want to make the following submissions. One, policy is within in terms of tax revenue measures, that is within the mandate of the national government through the National Treasury, as well as Parliament on the legislative reforms that will be passed. Now, how these tax revenue measures are to be implemented, that is within the mandate of the National Assembly through its committees and the Committee of the Whole House. The courts from the High Court, the Court of Appeal, and the Supreme Court, on the first question, can they test the legality of the policy positions? Yes, it can. Confirm that due process has been followed, that there was public participation, that they met the statutory timelines, that they adhered to what the PFM Act, the Public Finance Management Act, stipulates in terms of the budget-making process. Anyone can challenge that. That is not in dispute. But where we depart from the decision, and the High Court got it right. I don't need to go into that much. Mr. Mahat went into it. The High Court got it right. When it comes to tax revenue measures, courts, just not in this country, but globally, have been very reluctant to step in to direct the government and Parliament on how to proceed. So the question is this, and this is the second question that the court has asked. If the court can test the legality, it can. The second question is more important. If so, whether the impugned section of the Finance Act relating to various tax legislations are unconstitutional, the evidentiary and legal burden is on a petitioner to demonstrate, item by item and clause by clause, that this particular item infringed this article of the Constitution, and as a result of this policy, infringed this article of the Constitution, and as a result, it is unconstitutional. That is a burden that you cannot make sweeping statements. You must identify item by item and the article infringed. And when you do that, then the court can intervene and then determine that this is not compatible with the Constitution, or there's no rational, it does not serve any rational, there's no rational justification under the law of the Constitution. To that extent, it's possible. And as to the particulars, the KRA will address you, but there's a very limited jurisdictional mandate for the courts to intervene on tax and legislative measures to raise revenue, because that is within the mandate of the National Treasury and the government of the day. The court only has to ensure that in doing so, the public participation is undertaken and there's adherence to both standing orders, then the statute and the Constitution. So the intervention can be only very limited.